Well, got a problem? Tell Michelle, because she gets results.
And tonight, she is helping a woman battle a big bank. She joins us now with the details on that story. Michelle?
Yeah, if you've ever tried closing an account when at a bank when a loved one dies, let me tell you, it's not always very easy. You might think all you need is a copy of their death certificate and the will naming you the beneficiary. But as Joyce Foster of Mesquite learned, none of that documentation was enough after her mom passed away.
They said they don't pay attention to the will. The will was of no value to the bank.
Joyce Foster couldn't believe a financial institution wouldn't take a legal document like a will as proof she was the beneficiary of her mom's checking account. Even more frustrating, before her mom's death, Joyce says they went to Wells Fargo in Mesquite together 3 different times to name her the beneficiary of the account. However, after her passing, Joyce says Wells Fargo couldn't find any of the paperwork. So Joyce went to her lawyer, who had her fill out a form called a small asset affidavit to clear up the matter. But Joyce says the bank refused that legal document too.
They said, no, that wasn't sufficient. How do we know it's a valid form? I said, well, call your legal department and ask them, which of course they wouldn't do.
So she called me for help.
I called you because I didn't know what else to do. Well, within 10 minutes of my first conversation with you, Michelle, you told me I needed this letter of testamentary and like a probate or something, and letter of testamentary, which was more information than I'd had in weeks.
See, when trying to close an account for a loved one after their passing, you'll need more than just a copy of the will naming you a beneficiary.
You actually have to go through a court process called probate and get an official letter from the judge naming you the beneficiary. Almost every bank in the nation requires that letter, and some require even more documentation, like death certificates and social security numbers.
After talking to me, Joyce hired a new lawyer who started her ex parte probate process. 4.5 months after her mom had passed, she's finally getting some answers and closure.
It's been a huge relief. After I talked to you, I was way in over my head because they weren't helpful, so I wasn't helpful, and the attorney wasn't helpful. So finally I get somebody like you, Michelle, that is willing to listen and help.
Now get this, if Joyce had been listed as the beneficiary on her mom's account, none of this drama would have occurred. Joyce says her mom did list her as the beneficiary, but for some reason the bank couldn't find those records. Joyce also thought since she was power of attorney for her mom, she'd have access to the account. But unfortunately, those rights disappear after the person's death. So a word to the wise, especially if you have an older parent and you can actually relate to this situation, get yourself listed as the beneficiary on their account or have them add you to the account. It's going to save you a lot of time and heartache after their passing. And I will be keeping in touch with Joyce as she goes through probate. I'll let you know when this battle is finally over and she's got that money in hand.
A lot of people think a will is the end-all be-all, but it's really just a piece of paper.
Yeah, until you go through probate. And here, and a lot of times when we're not talking about a lot of money, maybe it's $11,000, you know, $20,000, judges don't want to go through probate. The lawyers don't want to go through probate. So you got to kind of twist their arm.
Good job.
Thanks, Michelle.
Yeah.